Can an executor override a beneficiary? Yes, an executor can override a beneficiary's wishes as long as that executor is following the will or, alternatively, a court order. Executors have a fiduciary duty to the estate beneficiaries that requires them to distribute estate assets as provided in the will. This means that an executor can override a beneficiary's wishes if those wishes contradict the express terms of the will. If a situation is unclear, an executor should get direction from legal counsel, and if necessary, they can seek the advice of the probate court. Can beneficiaries override an executor? No. Beneficiaries cannot override an executor unless the executor breaches or fails to follow the will and breaches their fiduciary duty. While beneficiaries can often disagree with an executor's decisions, unless the executor clearly violates the terms of the will or breaches their fiduciary duty by doing so, there's typically nothing a beneficiary can do about it. In many situations, beneficiaries can't override a legally appointed executor just because they don't like the decisions they're making. However, if a beneficiary believes that the executor is not following the terms of the will, they have the legal right to ask the court to appoint a different executor. Typically, the court won't remove the bad executor unless the beneficiary can prove misconduct or incompetence. Beneficiaries who suspect that an executor is violating the will or their fiduciary duty should seek the counsel of a skilled probate litigation lawyer as soon as possible to make sure the wishes of the decedent are followed before too much harm has been done. Can an executor override a will? No, an executor cannot override or modify the terms of a will, with a few exceptions. In fact, as a fiduciary to the estate beneficiaries, executors are legally required to abide by the will throughout the entire probate process, including the distribution of assets to the named beneficiaries. Except in very limited situations where the will terms cannot be followed, an executor cannot override the intent of the will to change the distribution scheme or remove a beneficiary. What is an executor of an estate? An executor of an estate is usually nominated in a will, or where there is no will, appointed by the court based on statutory preferences stated in the probate code. Executors are responsible for handling the decedent's estate, putting the will into action, and working through the probate process to distribute assets. Duties of an executor include 1. Marshaling the estate assets, gathering everything that should be in the estate. 2. Paying the estate's debts, taxes, etc. 3. Distributing the estate's assets and property as dictated by the will. Under California law, anybody 18 or older that has not been judicially determined to be incapacitated can serve as an executor. While executors are often close relatives or family friends, some people opt to select a disinterested third party as the executor of their estates. If the executor is a family member, oftentimes they'll also be a beneficiary. Can the executor of an estate be changed? Yes. California law allows an executor of an estate to be changed in certain situations. Under the probate code, executors can be removed or changed if 1. They waste, embezzle, mismanage, or commit fraud against the estate, or there's evidence that shows they're about to do so. 2. They're found to be unable to properly execute their duties, or they're simply unqualified to serve. 3. They wrongfully neglect the estate or fail to perform duties over a period of time. 4. They need to be removed to protect the estate or interested parties. 5. There's another cause for removal under California law. If an executor's fitness is challenged, the probate court will conduct a hearing to determine whether they should be removed and who then should serve as executor. Interested people who have an interest in the estate, like the deceased spouse, beneficiaries, heirs, creditors, and possibly other alternative executors, can participate in the hearing. If the judge believes there are grounds for removing the executor, they can terminate their appointment and appoint their replacement. Have questions? We protect people like you every day. Give us a call, shoot us an email. The consultation's always free. Thanks for watching.